Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Ms. Sheela Murthy to discuss the latest updates, followed by AOS and adjustment of status issues and concerns. You can call the numbers displayed on the screen and ask any question related to immigration, and attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice and it is general in nature. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. Please reach out to the attorneys for a private consultation for a case-specific issue. Hi, Ms. Murthy, how are you?
Hi, good evening, everybody. Welcome and delighted and honored to join you all today.
Yeah, you all know Ms. Murthy is the founder, president, and CEO of the Murthy Law Firm and a Harvard Law School graduate. She's also the one behind the famous Murthy.com website. Before getting into the session, could you please introduce yourself and then we can take it from there?
Sure. Thank you so much, Ranjit. As you just heard from Ranjit, Murthy.com was started over 27 years ago, and our goal is to educate, empower, and enlighten each of you that is going through the complex, stressful, and difficult time of whether it's non-immigrant visa like H1L1 or F1 or green card process or citizenship for that matter. And our goal, of course, is to provide the latest information through the weekly Murthy Bulletin that goes out to tens of thousands of people, the Murthy Forum, which has several tens of thousands of people participating, exchanging live questions and answers with attorneys, reviewing and monitoring and providing guidance, as well as other questions that we answer, and through forum like this, where we have an opportunity to continue to educate with you through, educate and empower each of you through different medium. So thank you for the opportunity. And again, besides Murthy Law Firm, we have the Murthy Immigration Services Private Limited, headquartered in Chennai with offices in Hyderabad and Mumbai, as well as the Murthy Naik Foundation, whose goal is to empower different constituents who have suffered injustice in the United States and in India. Country of birth, of course, is India, and country that has adopted me is the United States of America. That was a long introduction. Thank you for allowing me.
Thanks, Ms. Murthy. We have a caller, Lakshmi. Let's take the call. Hi, Lakshmi. Welcome to the show. Please go ahead and ask a question. Hello.
Lakshmi, hello. Do you want to go ahead, please?
Looks like the call disconnected. Okay. Before starting the show, do we have any updates? I believe the visa bulletin is released. So please, could you brief about it and then we can continue?
Sure. Thank you so much, Ranjit. So the visa bulletin has in fact just moved forward, and two quick updates. One is, besides the visa dates having moved quite a bit, I think EB2 now is August 2010 and EB3 is May 2011. Charlie Oppenheim, the gentleman in charge for the U.S. Department of State Immigrant Visa Control Unit, is now not only doing the YouTube video updates, he's also going to have monthly conversations and discussions explaining and answering questions from the general media about policy and questions on the U.S. Department of State and the visa bulletin. So this is brand new, and that's going to start from this month, April 2021. And of course, last month he started the first one where they gave it, but they didn't open it up for questions and answers from the public. So clearly the Department of State understands that people are very confused and troubled and do not understand how the whole visa numbers move, which nobody, I think, completely understands the nitty-gritty the details of it. And Charlie Oppenheim literally lives, eats, and breathes the immigrant visa numbers for the Department of State for the last 25, 30 years. I know since I've been practicing, which is like over 30 years, that he's been the person in charge.
Thanks, Ms. Murthy. We have the caller again. Hi, Lakshmi. Welcome to the show. Please go ahead and ask a question.
Hi, hello, madam. So I have applied for my H4 and H4 EAD extension on September. So I was waiting for my biometric appointment and approval for a long time. So I traveled to India for my other work. So I traveled to India and I got my H4 approved on February. And now I received my biometric appointment last week for myself and my daughter. My question is, should I go to the biometric appointment or not?
Lakshmi, I would strongly suggest that you absolutely attend the biometrics appointment, because was this an extension of status that you had filed, or was it a change of status, your H4 with H4 EAD extension, right?
Extension, yes.
Okay, so extension of status is not deemed abandoned upon departure from the United States. Technically, the USCIS should continue to approve both the H4 extension and the EAD, and depending on which one is the last, you could decide. But the bottom line is you are in H4 status right now. You absolutely should attend the biometrics interview, because what's the worst that will happen? Because if you don't attend it, then you have no chance that they will consider your EAD application, and we would rather it continue. We have heard of some people saying they were allowed and they got the EAD. We have heard other people saying when they traveled abroad, USCIS issued a denial of the H4 extension, saying you no longer require the H4 extension. But if they do that, you have to reply and say, no, H4 extension of status is not deemed abandoned upon departure from the United States. Accordingly, please continue processing the H4 EAD as required, because you have paid the filing fees, legal fees, and processing fees for processing those forms. So please go ahead, Lakshmi. I would not miss out this opportunity. All the best.
Thanks, Lakshmi. Thanks for the call. So, Ms. Murthy, yeah, recently I believe USCIS released some stats saying that, last year they wasted about 9,000 green cards or something. And this year you very well know that there are, I believe, about 120K extra green cards roughly. So what do you think is going to happen? Is there a possibility that USCIS will adjudicate the applications and use the numbers, or are they going to, waste it like they wasted last year? Last year, in just 140K, they wasted about 9,000 green cards. So now the number is almost double. So what are your take on it?
Sure. So by law, all unused immigrant visa numbers are supposed to be ultimately used by the Department of State and USCIS, which is why Charlie Oppenheim explains how USCIS works in unison with the Department of State. So Department of Homeland Security and Department of State work together to make this happen. So will the numbers get wasted? They very well could, because remember, COVID-19 is still continuing. I heard the latest that there's many major problems in many countries, including India, where the reported number of deaths is far below what we're seeing in crematoriums and cremation sites, which is very scary. Apparently, we're having a double mutant. So whether they're going to, again, institute some type of lockdowns where several countries, I believe Boris Johnson, the UK Prime Minister, was supposed to visit Narendra Modi this week, but was planning it, had reduced the time from 5 days to 2 days, and now has canceled the trip. So people are nervous to travel to other parts of the world, including in India. Will immigrant visa numbers get wasted? There's a high chance, because of COVID-19 restrictions, that maybe we will not be able to use all of the numbers. But by law, they are supposed to recapture the unused visa numbers and use it within the next fiscal year. So that is the reason that Charlie Oppenheim had explained that we would get, instead of 140,000, we would get, like you noted, approximately close to double, 270,000 immigrant visa numbers in the employment-based category, plus family-based category also has greatly unused numbers, primarily because of Trump's presidential proclamations, which Biden continued for another month. He stopped the immigrant visa proclamation, as you know, in late February 24th, I believe, 2021. And the H1L1, J1 presidential proclamation, of course, expired by its terms on March 31st of 2020. So we do expect that a lot of these immigrant visa numbers could very well get wasted, but they are supposed to be used. And there is now legislation that both Biden has introduced and has been introduced in both separate bills in the House of the US Senate and the House of Representatives to try and capture immigrant visa numbers. In fact, the American Immigration Lawyers Association is having our National Day of Action this Thursday, which is in 1 day, in 2 days, 1.5 days. And we are going to be meeting senior representatives in every state across the United States, all of the 50 states. And we are going to present what we expect from them, including recapture, clear process and policy to ensure that immigrant visa numbers are not squandered and wasted, and that there's a system in which we can continue to ensure that all of the immigrant visas that are supposed to be issued and usefully are being used in each fiscal year? And if not, how are they going to be able to recapture them and use them as quickly as possible? Because there is a whole system and formula, but as we know, for the last year, it has certainly, in the last 4 years, it has certainly been challenging to say the least.
So you mean to say that, let's say this year about 260,000 green cards are there and USCIS is unable to allocate all of them, and let's say few are wasted, so will they be adding it to the next year?
That's the process. It's supposed to be added, and the whole system where Joseph Biden, on the first day that he became the president, he actually introduced the bill that talked about recapturing every unused visa number and making it almost like you can use it almost for eternity. We are very concerned because the whole idea of creating the quota system was to encourage the economy, the business, to bring much needed skilled labor and to reunify families. If we are not doing what we promised under the statute, in the law, then we have basically misrepresented to the American public and to businesses that need high-skilled workers and need to process them on a permanent basis, that we are not complying with what we had promised to do under the law. So yes, they are absolutely 100%, Ranjit, supposed to figure out how we can use this and not have to use them within that fiscal year. And I think that's what the whole system of ensuring the recapture of immigrant visa numbers happens, even if the fiscal year has expired.
Got it, Ms. Murthy. So we have a caller, Nagarjuna from Pennsylvania. Let's take the call. Hi, Nagarjuna. Welcome to the show. Please go ahead and ask your question.
Hi, Ms. Murthy. Thank you so much for taking my call. I have one quick question, please. My daughter is, she's actually 21 last year. So her date of birth is November 24th, 1999. And when the dates became current last October, we applied 485 in filing date. And today, in today's final action date, it is current. So my question is, should we go for a premium processing of Y-140 or not? I mean,
so I want to understand, was this a EB3 downgrade case? Was this? Yeah, we don't want to get too much into case specifics, obviously, with dealing with your whole life. But if it's an EB3 case, then you need to know if it's going to be approved, because if it gets denied, then you have nothing. And your daughter, depending on how long your original I-140 was pending, that time may be able to be recaptured. But if you're basing it on the new case, but she already turned 21 before you filed it and you were using time based on a prior I-140. I mean, to tell you the truth, Nagarjuna, Child Status Protection Act, CISPA cases are very complicated. And unless you examine carefully the exact number of days and how you can try to get credit for it so that you can try to make an argument. But if it's a new EB3 downgrade case that wasn't pending even for a day, your daughter was already 21 from last year, then I'm not even clear how she would be protected and if her age would be frozen under CISPA to protect her and give her the green card. Hopefully, in the meanwhile, you and your family had also filed a change of status for her from H4 before her 21st birthday to F1 status about a year before. We tell people to do it 1 year, even 2 years before, so that is pending, because there is certain USCIS policy guidance that explains that even if the child applies for the 485 and it's ultimately denied, if the child also had applied for an F1, the F1 status will allow the child to have a valid non-immigrant status in the United States. Only if the child travels abroad and comes back, then they jeopardize not being able to come back on the F1 status. So if you don't have other backup status, there's potential risks, because I'm not clear from the little bit that I've understood that your daughter would be completely protected under Child Status Protection Act. Hopefully your company lawyer is sitting down and discussing that with you. And if you're not comfortable or they're not aware of what to do, certainly feel free to consult with either Aaron Finkelstein or Chris Drynan or myself at the Murthy Law Firm, because we deal with these situations quite regularly. But I'm very, very concerned that we might be losing time. And if she already turned 21 a year ago, I don't even know how she would be protected in this case.
We did F1 through via your Murthy law firm only. Attorney Andrew helped us. So she got her F1 last year, but we already applied her 485. She's on F1 right now, so there's no problem with that. But we already applied on October 23rd, where she is still not reached 21 years yet. She's like 1 month short of 21. So now, I think even if because it's current and if it's approved today, I think her age will be lost. So other aspects, yeah, I'm going with your firm's help.
Well, her date may not be lost if it gets approved today because it's been pending. Oh, because she was already going to become 21 in 1 month. So that was very tight. We only had 1 month grace period. So that's the risk, is that, yes, we very well could have lost it. Now, I will tell you, because of the multiple lawsuits, and we are hoping, Nagarjuna, that the Biden administration will issue some type of guidance or clarification, because only till about 2 years ago, this issue was not clear. Everybody who filed a 485 was protected because we didn't have a difference between date of filing and final action date. That was only introduced in the last several years. And so all of the cases that were filed, we didn't have clear-cut answers. I don't know if they're going to change, because remember, the whole idea of the CSPA was to protect the child and to reunify families. And to ensure that, children weren't separated from families. So it's possible that the Biden administration will change the interpretation that we saw implemented during the Trump administration. And I know that several people have thought of suing, but it's sort of not very clear right now. Based on the current law, you probably won't be protected. But if your child has at least F1, then she's got some status. In the meanwhile, do the H-1B dual intent when she finally gets a job after the F1 OPT for 1 year and then STEM OPT of 2 more years, then H-1. And in the meanwhile, if the green card is approved, great. But if it doesn't get approved, there's at least no panic that you have to pack up and just to leave the country.
Nagarjuna, I hope you got your answer. Ms. Murthy, following up with the last question, Nagarjuna. So, how will USCIS track all these? Let's say someone's kids is aging out in next few months, and this month the dates move significantly, and let's say the kid is now protected and the age will be locked. But how do we communicate, or USCIS communicate with us that your age is locked, you don't have to do anything?
So I always tell people that the USCIS is not your lawyer. They are not there to fight and help you. They just follow the law. And it seems like, at least in the last 4 years in the past Trump administration, they almost act like not that they're following the law, that they make up the law or create the law in a manner to put hurdles to not help immigrants going through the process, whether on H-1 or green card. So ultimately, your lawyer has to sit and really look at it carefully to say, okay, here is the date, here is the filing, this is how long I-140 petition was pending, this is when the child turns 21 years of age, this is how we are going to be able to see whether there's a chance to get this approved, not get it approved, all of those factors that we would really need to examine carefully. The government really doesn't seem to care a whole lot. Their attitude is, denied, because you know why? The child turned over 21 already, or the time that the I-140 pending that is subtracted from the age of the child won't help, for example, in Nagarjuna's case, because the child only had 1 month grace period when they filed the 485 in October of 2020. The child was going to turn 21. If the child had 1 year, now the final action date would be fantastic. But you know what? The priority dates didn't move for so many years. It was now, because of non-usage, they're trying to approve more and more and more cases faster. So people whose children are a little bit younger may benefit. In this case, Nagarjuna's child, at least, thank goodness, because we know so many people who filed the 485 and did not file a backup non-immigrant status. Unlike Nagarjuna, that was smart and creative and proactive. And then the child now is considered to be out of status, and from the date of denial is unlawfully present, cannot continue the education, is required to depart, because if they stay longer, then they would trigger the 3-year and 10-year bars, which is really like the kiss of death. So please be proactive and tell your children to also read up immigration law and be prepared, because part of growing up and becoming an adult is not just going to bars or driving or drinking and all of that. It's also the responsibilities that come with becoming an adult. As my parents would always tell me, this is your life, Sheela. You have to take responsibility for it. And teaching our children those values, I think, will make them stronger and better, because in India, many of us grew up feeling a little bit protected by our parents. But in the West, here in America and in other parts of the West, children, once they cross 16 or 18, they are told you are on your own, pay for your own education, take your own student loans. So please don't smother your children with love. Let's make them strong, independent, young men and women that will contribute to both countries, to the country of their birth and the country of their ancestors, and make you as proud as parents. I know that's probably not immigration law advice, but many times people want life advice, not just immigration advice. And I know that all of us as parents try to do what we do because we love our children, but you don't want your love to prevent the child from becoming strong, tough, confident, and being self-reliant, reading immigration laws. I always say, no one else can study immigration law for you. No one can eat breakfast for you. No one can write your exam for you. So study the laws and make your children study with you, so that they completely appreciate much more the sacrifices that you all made as parents to give them a better life.
Thanks, Ms. Murthy. Thanks for your advice. So yeah, coming back to this EAD, EAP thing, a lot of people have a lot of questions. So let's say both husband and wife got the advance parole and EAD, and can just the spouse use the EAD even though the husband doesn't want to use? And how does it work? And how does USCIS know if they are on EAD or on H-1B or on H-4, whatever the status they have had?
So absolutely, both parties, when you file the adjustment of status, each of the two spouses, or all, in fact, even the children who are eligible and get the EAD, are allowed to maintain separate status. So if the principal is on H1 and the spouse is on H4, but has the EAD, the spouse absolutely can use the EAD and the principal can continue to stay on H1B status. How does USCIS know? They know from the information you complete on the form, because they say, what is your non-immigrant status? And the spouse may have written, he or she may have written H1B or H4. If each spouse has their own specific H1B, still either party can use the EAD. And once you use the EAD, you have a choice. You can come back on the advance parole, or if you still have H1B or H4 stamp in your passport and you wish to come back, you're still allowed to do that. There's been a lot of back and forth in various USCIS policy memos on what you can and cannot do. There's nothing clear-cut in the actual law in the Immigration and Nationality Act. So to a large extent, in many of these gray areas, we rely on USCIS policy guidance and the memoranda that they have been using to explain what their position is on certain issues. Of course, as we saw during the Trump administration, they said, well, there's this memo, but we decide to ignore the memo because the memo is not the law. So they, like good politicians, are blowing hot and blowing cold with us. But at least if you have some legal basis to follow what makes sense. So absolutely, you can use either party can use EAD. One can use EAD. How the USCIS knows what is in the form is based on the information that we provide, and they will double check. Okay, your status expired on this day. They can check, do you have an H1 approval? Do you have an H4 extension? They will see the expiration date that you mentioned on the form as when is your status expiring.
Got it, Ms. Murthy. So you mean to say the I-9 form will work as to prove which status you're working on?
The I-9 form is something that's provided the requested by the employer, provided by the employee, confirming their status and the eligibility to work, that doesn't confirm. That's only evidence meant by an employer to submit to prove that they have done their homework, due diligence in ensuring that the employee is legally authorized to work in the US. So if the employee says, I want to use the H4 EAD, that's fine. If the employee says, no, I want to use the I-485 EAD, then you submit and provide that updated information to your employer on the I-9 form to confirm what status and when it expires. But that's not the form on which USCIS relies. USCIS doesn't look, because the ICE, Immigration and Customs Enforcement, when they're doing audits of employers, that's when they ask for the I-9 employment verification form. USCIS looks at the form, like the I-485, if it says, what is your status? And if you're the principal, you write H1. If you're the dependent, you write H4, or maybe both. Even the dependent could write H1, because very often both parties in the marriage, spouse, wife and husband, both have their own H1B. You can write H1 and the expiration date. They look at that, but they can also double check from the USCIS database itself, from the approval, if that I-94 card is still valid or if it has expired, that approval notice with the I-94 card attached to it at the bottom of the approval notice.
Thanks, Ms. Murthy. Another question a lot of people have is, starting or running a business on EAD or AP. Can spouse start their own business, or can the principal also have their own business? Are there any restrictions for principal or spouse or anyone? Could you please just give a brief?
Yeah, so this is fairly common question. Of course, many immigrants, including Indian immigrants, are very creative and entrepreneurial. They want to live the true American dream of building a good, strong financial nest egg or future for themselves and their families. If a person has a valid, unrestricted EAD card, then the person is allowed to start any kind of business or do whatever they wish, as long as that EAD is valid for them. Sometimes what happens, the EAD is valid and then there's a gap because they didn't file the extension in time. Then during those few months, the person is not allowed to work for that business. So I tell people it's probably a good idea to team up, if you can, with a US worker, citizen, permanent resident worker that can continue doing the business if your EAD has expired or lapsed. So depending on so both spouses are allowed to do it. If the person wants to maintain H-1B status and not use the EAD, then the principal should not work on the EAD, the principal green card applicant. But if the person says, look, I'm willing to extend my H-1B and I want to work on the EAD, that is possible according to USCIS. So you can certainly take advantage of it. As I said before, there's lots of black and white areas that are clear-cut, allowed or not allowed in immigration law, but majority of the issues, including this issue, there's some gray area. So you need to be very careful that you are not breaking the law with respect to black and white issues. But where there's gray area, you want to be as clean and protect yourself so that you're not doing anything to violate your status.
Thanks, Ms. Murthy. We are towards the end of the show. Again, thanks for your time. Thanks for all the calls and watching the show, audience. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday, 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Ms. Murthy.
Thank you. Bye-bye.